Hello friends, welcome once again in our series on the cases of various judgments decided by tribunals and high courts and Supreme Court. And today we have come up with a very unique issue on the period of limitation under section 153C. The period of limitation in respect of assessments under section 153C is a big area of dispute. Although it is a settled issue, but in many cases we can take the benefit of this legal issue of the limitation in case of searches and the assessment under section 153C. This issue has been taken by Delhi ITAT E-Bench in the case of Esha, Securities Private Limited versus Deputy Commissioner of Income Tax, and this matter is reported in 114 ITR Tribunal short notes 24, and the date of the judgment is 30th May 2024. The assessment year which is concerned in the present case is assessment year 2004-5. In case of searches, before 1st April 2021, the assessment of the assessee on whom the search is conducted is done under section 153A, and the period of 6 years for making the assessment is calculated from the date of the search. But in case of those assessees whose documents are found in the search of the searched assessee can be assessed under section 153C, and for those assessees the period of computing 6 assessment years for which the revenue can do the assessment is computed from the date on which the assessing officer of the searched assessee handovers the documents relating to the non-searched assessee to the assessing officer of the non-searched assessee. For example, the search is made on A, and in the search of A, the documents relating to assessee B are also found. So, the date on which the assessing officer of A will hand over the documents to the assessing officer of B will be deemed as date of search, and the period of 6 years will be calculated from that date. In the present case, the documents were handed over on 23rd November 2010. So, the period of limitation of 6 years should be calculated from the period ending 31st March 2010. If we go 6 years back, then that the last year will become assessment year 2005-6, because if we calculate the period when the documents are handed over, that is 23rd November 2010. So the financial year ending is on 31st March 2010. So the assessment year is 10-11. If we deduct 6 years from 10-11, then if we deduct 6 from 11, then the assessment year 5-6 will be the last year. And since in the present case, the assessment year in dispute was assessment year 2002-4, so by taking the date of the handing over of the documents by the assessing officer of the searched assessee to the assessing officer of the non-searched assessee, the 6-year period will lapse, and in the present case the assessment of assessment year 4-5 is time barred as per the limitation period. So friends, this case is very important. Now the question arises, why the date of search is not taken as the date of search in case of the non-searched assessee? The reason is that because sometimes it happens that the revenue takes a lot of time in handing over the documents to the assessing officer of the non-searched assessee. So the non-searched assessee cannot be expected to keep the records for such a long period of time. So the date of handing over of the documents is treated as date of search for the non-searched assessee. So in the present case, the assessment of the assessment year 4-5 was quashed by Delhi ITAT e-bench in the case of Esha, Securities Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 114 ITR Tribunal short notes 24, and the date of the judgment is 30th May 2024. Thank you, friends.